Committee on State Affairs will come to order. The chair lays out Senate Bill 2117 by Senator Parker and recognizes its author to explain the measure.
Thank you, Mr. Chairman and members, for allowing me the opportunity to come before you here with Senate Bill 2117 this afternoon. Members, this session, we have witnessed spirited debate regarding the acquisition of property in this state by individuals and entities with ties to countries such as Iran, North Korea, China, and Russia. This debate has presented an opportunity for us to consider the interplay between our own security concerns here in Texas and the Federal Committee on Foreign Investment in the United States, the CFIUS process. CFIUS reviews inbound foreign investments for national security issues, negotiates mitigation measures where needed, and may sometimes block transactions outright. Senate Bill 2117 seeks to propose a complementary channel to resolve these security concerns by establishing a state-level process to identify and evaluate high-risk foreign transactions. Modeled in part on CFIUS, Senate Bill 2117 creates the Texas Committee on Foreign Investment, empowering the state to review proposed transactions, to mitigate risks to critical infrastructure, and to coordinate more effectively with federal authorities if necessary. As background, President Ford established CFIUS by executive order in 1975. In 1988, Congress adopted the Exxon-Florio Amendment to the Defense Production Act, granting the president authority to block certain transactions that pose national security risks. Today, the Secretary of the Treasury chairs the CFIUS process, which includes representatives from the departments such as Justice, Homeland Security, Commerce, Defense, State, and Energy, among others. The Director of National Intelligence and the Secretary of Labor serve as non-voting members. Over the years, CFIUS has expanded its jurisdiction to include transactions in critical technologies, critical infrastructure, or sensitive personal data, as well as certain real estate deals near sensitive installations. Filing with CFIUS is mandatory. Filing with CFIUS is mandatory for specific types of transactions, but much of the process remains voluntary, relying heavily on transaction parties to do the right thing and to notify the federal government. If CFIUS identifies potential risks, especially where a foreign government or a government-controlled entity may gain sensitive control, an investigation follows. The committee can negotiate mitigation agreements to reduce national security threats. In our constitutional system, federal law is supreme and may preempt state law in one of two ways: by explicit congressional direction or implicitly, when state law stands as an obstacle to an accomplishment and execution of the full purposes and objectives of Congress. While the CFIUS statute does not expressly preempt state law, there is a plausible argument that a sweeping state-level restriction could be vulnerable to implied federal preemption if it conflicts with or frustrates federal objectives. Furthermore, Congress has repeatedly revisited and expanded CFIUS authority, and it could choose to bar states from conducting overlapping security reviews. This underscores the importance of crafting a framework here in Texas that complements the federal process. And that is precisely why Senate Bill 2117 is structured as a state-level protective measure that aligns with the spirit of cooperative federalism. By establishing our own formal committee, the Texas Committee on Foreign Investment, we position the state of Texas to better identify security risks and non-notified transactions, to gather relevant local and state information, and as needed, feed those insights to federal regulators. Under CFIUS, a non-notified transaction refers to a covered foreign investment or acquisition that meets CFIUS's criteria for review, but is never voluntarily submitted to the committee by the parties involved. While many transactions undergo CFIUS scrutiny through formal notification, non-notified deals are those that the parties do not bring to CFIUS's attention, even though such transactions may still raise potential national security concerns. CFIUS has the authority to investigate non-notified transactions on its own initiative if it becomes aware of them through intelligence channels, public reporting, or input from state or local authorities. Rather than creating a conflicting regulatory regime, our proposal provides an early warning mechanism that flags potential problems, encourages mitigation, and thereby minimizes the risk of federal preemption. Under Senate Bill 2117, the Office of the Attorney General will receive notification from the Texas Committee on Foreign Investment of certain higher-risk foreign transactions. It will conduct an initial and, if necessary, full secondary review, and then report its findings back to the committee. If a mitigation agreement is in fact needed, the Attorney General and the committee can impose specific measures: data protection protocols, limits on foreign access to certain infrastructure or technology, and much more, including the ability to stop a transaction completely. Members, I believe Senate Bill 2117 provides a balanced approach to strengthening our capacity to protect Texas's most critical infrastructure, its sensitive personal data, and key industries, all while maintaining a favorable investment climate and preserving alignment with federal authority. By establishing a state-level mechanism for identifying and mitigating risks, particularly when transactions might otherwise go unreported, we enhance Texas's security without overstepping. Thank you, Mr. Chairman and members, for the opportunity to lay out the bill. I greatly appreciate the opportunity. I'd be happy to answer any questions and talk about all this process if there's interest.
Thank you, Senator. Any questions for the author? Very well. We'll open public testimony on Senate Bill 2117, 2117. Is there anyone wishing to testify on, for, or against Senate Bill 2117? Seeing none, public testimony is closed. Bill's left pending at this time. Thanks, Senator.
Thank you, Mr. Chairman, members.
Calling up Senate Bill 2881 by Senator Hughes to explain the bill.
Thank you, Mr. Chairman. Senate Bill 2881 has to do with digital providers and the safety of minors online. Many here were involved in the joint committee on the effect of media on minors. That committee had a hearing in January, at the end of the last legislature, right before this one, and heard some compelling testimony. And so the failure of digital providers to protect the safety of minors online is what spurred the SCOPE Act from the last legislature, HB 18. It required internet sources to implement systems that give parents more control over their children's online activity and prevents obscene material from being easily accessible. Following up on the protections in the SCOPE Act, this bill will mandate that digital service providers establish controls and default settings for known minors. And the default settings for the account of a known minor must be set too, limiting the amount of time spent using the service to 1 hour each day, prohibiting unsolicited messages from unknown users, prohibiting comments, likes, or reaction to posted conduct by the minor, prohibiting public display of a minor's list of friends, contacts, or followers, and prohibiting the use of algorithms to show or promote content on the digital service. Again, this is about minors. Parents would at any point be able to change these settings. We have Dr. Linda McGee, who testified at the interim hearing, the joint committee hearing, and she'll be here to speak about this bill and answer questions. But again, it's about protecting minors online. I'm happy to yield for questions.
Members, any questions? Okay.
Thank you, Senator Hall. We'll open testimony on Senate Bill 2881, and the chair calls Lindy McGee, Dr. Lindy McGee. Dr. McGee, welcome back.
Thank you.
Make yourself comfortable and then introduce yourself, give us your testimony.
Sure, happy to be here. Thanks for having me. My name is Lindy McGee. I'm a pediatrician in Houston, and I'm representing Texas Medical Association, Texas Pediatric Society, and myself. And I'm here to testify in support of Senate Bill 2881. I come to this space as a pediatrician who, with a background in advocating against the use of addictive substances in minors. So I've been before this committee this session talking about THC as well. And what I'm seeing is everyone from toddlers to young adults staring at their phones. The algorithms used by these platforms are drawing kids in so much that I'm having kids that are staying up all night on these and then failing school. I also had a young girl last year who came to me and said that a social media app told her to develop her eating disorder. And talking to colleagues are seeing this more and more. So while social media is not physically addictive like alcohol, nicotine, and THC, we know that the use of this stimulates the same areas in the brain and these dopamine reward pathways. A 2024 Pew Research survey showed that almost half of U.S. teenagers said that they were on their phone almost constantly. That compares to 1/4 of teenagers in 2015. We do restrict activities like gambling and use of alcohol and nicotine to those who are over age 21 because we know that the adolescent brain is especially primed for addiction. With social media, it's not as easy as simple restriction because it is pervasive in our culture, and it can be used for good things like social interaction, learning, and creativity. And this has made parenting really difficult. Parents often struggle to keep up with all of the different platforms their kids are on and what that means for online safety. So we really commend this bill's aim to establish protective default access and communication settings for minors, relieving parents from having to navigate each platform individually. First, limiting social media time. A study of U.S. adolescents aged 12 to 15 found that adolescents who spent more time on social media face increased risk of experiencing poor mental health outcomes, including symptoms of depression and anxiety. A randomized controlled trial in college-age students found that limiting social media use to 30 minutes a day decreased depression severity scores. Excessive use has also been associated with poor sleep quality, decreased sleep duration, and attention problems. In one survey, 1 in 3 adolescents report using screen media after midnight on weekdays. And an astonishing number report sleeping with their phone in their hand every night. 2, prohibition of messaging from unknown users. There is no reason an unknown adult needs to be messaging with a child. I think everyone can agree on that. We need to be aware of the dangers of trafficking on these platforms. The third one is the prohibition of comments, likes, and reactions for minor users. And this falls into the area of social comparison, comparing the number of likes that you're getting on your photo that you posted versus the likes that your friend is getting. And we know that social comparison driven by social media is associated with body dissatisfaction, disordered eating, and depressive symptoms. Protecting the privacy of minors' friends and followers also follows into that social comparison. But a psychologist friend who I had read the bill and asked him questions about it also pointed out to me that he sees a lot of patients who are cyberbullied, and when they block their bully, the bully starts bullying them through their friends' posts too. So I think it would also help with that. And then banning the algorithm content recommendations. So this measure would reduce the addictiveness of the apps and limit the exposure to harmful content. And if you remember when social media first came out, you scrolled through and you got to an end. You saw your people you're following, and then it gave a little check mark, you're done for the day, and you put it down. Now it is just the endless scrolling with algorithms that are so smart at keeping your attention and keeping you on their product, because ultimately that's what they're selling. They are selling your attention to advertisers. For adults, that's fine. We know what we're getting into. For kids who have these very fragile or developing brains, it's not acceptable. So in addition to protective default settings, our organizations always advocate for evidence-based guidelines and public education on healthy technology use with resources from the American Psychological Association, American Academy of Pediatrics. We urge the legislature to continue addressing social media companies' data collection practices and restrict the data collection of minors. And I really thank you for your attention to this subject.
And thank you, Dr. McGee. Senator, is there any questions for Dr. McGee? Senator Parker, you're recognized.
Thank you, Mr. Chairman. Doctor, I just appreciate you being here and shedding a light on this enormous problem. I just think it's a huge epidemic that we've got to address, and appreciate so much the bill and its intent, and just thank you for raising awareness. I think the quality of the materials and the research that you have here just very clear, and we just need to communicate this to Texas families to understand what a risk it is to allow their children to have unfettered access to all these various social media apps. So, and all the time online broadly. So, thank you for what you're doing. Is there additional clinical data, I guess, right now that's currently being collected? Are there studies going on these topics here in Texas or elsewhere that are even broader than what you've obviously referenced here in your great piece?
Yes, so there actually is a big study being done in the state of Florida right now, and they released some results last week or this week. My weeks are running together at this point. And they are following a cohort of 11, 12, and 13-year-olds, and plan to follow them until through their age 25, I think is the upper age. So it'll be interesting to see what they show. And we just have this first report right now. It did find that kids who had phones were happier than kids without phones, which is not surprising to me, because if all your friends have a phone and you don't, and you're 11, that makes you unhappy. But it found that kids who post on social media had much higher depression type of scores. So posting on social, so having a phone was not correlated, but posting on social media. And I think it goes into that social comparison big time. And that's why I really like this, that parents have the ability to turn off the likes and comments. And I love that the parents have the ability to turn it off, turn it on. And it's default at the safest, and then as the parent knows their child and knows what's developmentally appropriate for their child, they can change the settings.
Absolutely. And with regard to brain research, I know we talked about the brain develops until 25. It really probably until the completed year 25, right? Maybe a little longer. Is that right? What is the latest science on that?
Obviously, it just depends on the kid, and any parent can tell you, and any parent who has multiple kids can tell you that they can come out of the same parents and develop at very different rates. So I think it's, I think we give 25 as the upper limit of normal when most people are, but development does what development does. So yeah, it doesn't follow the textbook timeline.
Yeah, thank you very much.
Dr. McGee, thank you for your testimony. A number of things you're working on here, and we're thankful for that. And that interim hearing, of course, in January, the end of the interim, a week or so before we started back here, many of these issues had been considered before by this committee and House committees, but that hearing, providentially, I would say, really focused on these issues, and your testimony and that of a few others really helped us crystallize some of the solutions. So thank you again.
Great. Happy to be here. Thank you.
Thank you, Doctor. We'll open public testimony on Senate Bill 2881 and ask if anyone present wishes to testify. Is there anyone wishing to testify on, for, or against, anyone else on, for, or against Senate Bill 2881? Saying none, public testimony is closed. Bill's left pending at this time. The chair lays out Senate Bill 2363, and recognizes its author, Senator Creighton, to explain the measure. Welcome, Senator Creighton.
Thank you, Mr. Chairman and committee. Appreciate each of you, and thank you, Mr. Chairman, for recognizing me on Senate Bill 2363. The secrecy of one's ballot is a long-held principle protected by Article 6, Section 4 of the Texas Constitution that every Texan reasonably expects when they go to cast their vote. Unfortunately, recent events have shown that bad actors will go to extreme lengths to obtain and publish someone else's ballot without their consent in order to further a political agenda or the latest news story. This legislation curtails these bad actors and seeks to protect the right to a secret ballot by making it illegal to publish someone else's vote without their consent. The bill provides a common sense definition of consent to ensure that consent is not falsely or unfairly claimed against the will of the individual voter whose ballot privacy is at stake. There is a committee substitute, Mr. Chairman.
Senator Hall sends up the committee substitute, and Senator Creighton's recognized to explain the substitute.
Thank you, Mr. Chairman. The committee substitute ensures that only defined public servants can claim the official investigation exemption in the bill without limiting the official investigation exception to a defined public servant. Then any person could claim their investigation is official, whether they're a public servant or not. We're certainly willing to work with the committee and stakeholders on continuing to improve how we see exceptions under the bill, but at the end of the day, it's very important that the integrity of someone's vote and their privacy behind that vote is protected. Thank you, Mr. Chairman. I know we have resource witnesses here from the Office of the Attorney General to help the committee with further answers.
And thank you, Senator Creighton. Senator Hall, you're recognized.
Thank you for this bill. I think the way we currently do elections, we absolutely need this to stop people from doing what they've been doing. But would you agree that it'd be better that we had an election process in which the secrecy of the ballot is guaranteed by the process itself, so that you couldn't identify any individuals, how they had voted?
I agree with the process, Senator Hall. I agree with ultimately any policy that would bring us closer to protecting the integrity and the privacy of a ballot that's cast.
Okay.
So I'll continue to work with you on that, and any other measures that accomplish that outcome, I think would pair very well with this bill.
Good, because I think we need this if we can't get the other done.
Thank you, Senator Hall.
Yeah.
And thank you, Senator Hall. Members, any other questions for Senator Creighton? Very good. Thank you for the bill. We'll open testimony on Senate Bill 2363. Public testimony is open, and the chair calls Ed Johnson, Kevin Hale, Dr. Laura Presley. So Ed Johnson, Kevin Hale, and Dr. Laura Presley are the only witnesses who have registered to testify on, for, or against the bill. So I'll ask, is there anyone else wishing to testify on, for, or against Senate Bill 2363? If so, please make your way in the chamber down to the table. Dr. Presley, welcome. Whenever you're ready, introduce yourself and go ahead.
Thank you, Senator Hughes. I'm Dr. Laura Presley, and I'm on the bill. I love the idea of the bill, that it creates a criminal offense for publishing how a voter voted. I'm in complete agreement with that. What is very concerning about the bill is the carve-outs, the exceptions of who is allowed to have it. And I just want to be real clear, the First Amendment of the U.S. Constitution and the Texas Constitution, I think it's Article 6, Section 4, that guarantees a secret ballot. It doesn't say that it can be secret from the public, but it's okay for elected officials or public officials or election administrators or the governor or the executive branch or the legislative branch to have access to it. That's not what the Constitution guarantees. So I believe that we should be very, very careful with any exceptions, because I don't think the U.S. Constitution permits exceptions, period. What I've handed out to you is in our case against the Secretary of State and 3 counties that have breached the ballot secrecy, not by the countywide polling location program, the Rinaldi ballot issue, but by the poll books that put a unique identifier on the ballots that breached the secrecy. And in this case, our court, the court has said nobody gets the data. And I just handed you the protective order that was signed by the judge. Not even the judge wants to see the voters. And the protective order says that just only one person in the AG's office gets to see proof of the algorithm that we found that ties every voter to their ballot. But it says do not release the voters. Even the court recognizes the First Amendment that nobody is to have the data, even the court. So I just want you to be so careful. I'm on the bill. I'm happy to work with the author on some language. But I just want you to understand that this is not just normal data. This is not something that y'all have probably dealt with before. This is scary data to have. When we found this data, I just have to tell you personally, I grieved for weeks. And it was emotionally just really distraught, and caused me to be really distraught to have this data. And no one should have it. When you go in the voting booth, it's between you and the Lord. And that's where it should stay. No one should get this data. There should be no exceptions to this felony. I'm here for questions if you have any.
Well, thank you for your testimony. Senators, any questions for Dr. Presley? Thanks for your testimony.
Thank you.
Is there anyone else wishing to testify on, for, or against Senate Bill 2363? Seeing none, public testimony is closed. Bill is left pending at this time. The chair now lays out Senate Bill 3013, 3013, to recognize its author, Senator Creighton, to explain the measure.
Thank you, Mr. Chairman. Members, Senate Bill 3013 makes necessary changes to the Texas Ethics Commission's requirements for financial disclosures from campaign filers. This bill does 3 important things. It protects the privacy rights of campaign filers by allowing campaign filers to not disclose the fair market value of their blind trust. Notices of late filings will be sent directly to the campaign filer instead of directly to the state prosecuting attorney, so that the filer has a chance to rectify or cure the issue before they're punished. It requires the privacy of home addresses for filers, not just a select few. Senate Bill 3013 ensures that sensitive information is protected and reasonable expectation of the right to privacy is maintained and not violated by the Texas Ethics Commission. There is a committee substitute, Mr. Chairman.
Senator Perry sends up the committee substitute, and Senator Creighton is recognized to explain the substitute.
The committee substitute makes non-substantive changes. It just converts the non-legislative council file draft into a legislative council draft, Mr. Chairman.
Thank you, Senator Creighton. Committee members, any questions for the author on Senate Bill?
And
Go
Mr.
ahead.
Chairman,
I'm sorry.
I did want to clarify, the bill maintains the statutory requirement for a statement signed by the trustee under the penalty of perjury, affirming that no information has been disclosed to the individual that would compromise the trust's integrity. This legal obligation acts as a safeguard against misuse, ensuring that the trust operates ethically. There are also other reporting requirements by any blind trust, but at the end of the day, this bill deals directly with the value of any assets held in the trust. Thank you, Mr. Chairman.
Thank you, Senator Creighton. Members, any questions, Senator Creighton? Senator Hall, you're recognized.
Is there clarity in there that a technical error is not an ethical violation?
I don't believe so in this bill, but I have another bill that I believe will address that.
Okay, because the issue, and I think we've talked about it, and it's probably not, maybe the other bill is that anything that happens with the Ethics Commission is tagged as a ethical violation.
Yes.
When there are simple errors that are made that has nothing to do with ethics at all, it still gets tagged as.
Yes, sir, and I believe in my final bill before the committee today that will be closer to the mark on that particular goal.
Okay.
Thank you, Senator Hall.
And thank you, Senator Hall. Any committee members, any other questions for the author on Senate Bill 3013? Very well. We'll open public testimony on Senate Bill 3013. Is there anyone wishing to testify on, for, or against Senate Bill 3013? 3013. Seeing and hearing none, public testimony is closed. Bills left pending at this time. The chair now lays out Senate Bill 3014, 3014, and recognizes its author, Senator Creighton, to explain the measure. Senator.
Thank you, Mr. Chairman and members. Senate Bill 3014 makes necessary changes to the scope of penalties that the Texas Ethics Commission is able to assess on campaign filers. This bill provides a more reasonable process for candidates for public office who make technical or clerical errors in their campaign filings. The bill requires a violation to be knowing for a civil penalty to be assessed and limits the civil penalty for a late filing to no more than $500. And it requires the failure to file a financial statement on 3 separate occasions before it becomes an actual criminal offense. Senate Bill 3014 aims to create a fairer system that distinguishes between intentional criminal misconduct and making simple mistakes. When your average Texan with a heart for public service, Mr. Chairman, makes a leap of faith to run for office, there's no guarantee of winning. The last thing that candidate needs, that aspiring candidate that might be self-funding his or her own campaign effort, is to quash their dream with burdensome penalties for unintentional mistakes in their campaign filings that might be down to a comma or simply making a mistake on an address by getting a zip code wrong in an area or a community that has multiple zip codes that are listed. When missing a comma leads to a high dollar fine that can be crushing for a candidate with minimal funds, Senate Bill 3014 will play a pivotal role in making public office more attainable for every Texan. There is a committee substitute, and again, the committee substitute simply takes a non-legislative council final draft into a legislative council draft. And with that, Mr. Chairman, I appreciate you and the committee members allowing me to present this piece of legislation today.
Thank you, Senator Creighton. And the committee substitute you explained is now sent up by Senator Hall. And Senator Hall, you're recognized to question the author.
Chairman. Good bill, badly needed. But let me make sure I understand that are we removing the penalties for technical errors like what you described in commas and numbers and things that, so you're not paying a financial penalty and we're going to rename those technical errors?
That's correct. And for any other errors, it needs to be shown that the candidate knew and intentionally made those errors, and there's a ceiling on the amount of fines to not be outrageous numbers, even in those situations. So yes, it accomplishes both, and I can provide you with a bullet point breakdown of exactly what the legislation offers on behalf of that candidate that may or may not ever even end up in public office, but we don't want deterrents and barriers for honest people that make simple mistakes. Thank you, Senator Hall.
Yeah, and on the being late, you said that's a $500 fine?
No, I'm saying that in a situation where an error is made and it is shown that that candidate knowingly filled out forms incorrectly, there would be a ceiling up to $500. The fine could be $50. The fine could be anything the Ethics Commission decides, but that would be the top end of it. If the violator knowingly, for a civil penalty to be assessed, it requires the failure to file a financial statement on 3 separate occasions as well before it becomes a criminal offense. And any violation, they would have to be shown as knowing for a civil penalty to be assessed at all. If it was assessed, there's a ceiling at $500.
Okay, got it. Very good. Good bill.
Thank you for that. Thank you, Mr. Chairman.
Thank you, Senator Creighton. Members, any other questions for the author? Very well. We'll open public testimony on Senate Bill 3014, Senate Bill 3014. Is anyone present wishing to testify on, for, or against Senate Bill 3014? Seeing and hearing none, public testimony is closed. Bill is left pending at this time.
Thank you, Mr. Chairman and members.
Chair recognizes Senator Hughes to explain Senate Bill 2217.
Thank you, Mr. Chairman. Senate Bill 2217 is about making election data consistent. It's we know that folks need to know what's going on. Transparency is important, not violating the secret ballot, but knowing how many people voted, and so that in addition to the election officials, the public and anybody can check the numbers and make sure everything is like it's supposed to be, make sure everything balances, make sure the numbers match. And so this bill is an important improvement in election accountability. It'll increase transparency in elections by requiring consistent data reporting across jurisdictions. The bill focuses on improving transparency, accuracy, and accountability in our elections by mandating, requiring consistent reporting, reconciliation processes, and enhanced capabilities for electronic voting systems. And of course, by that, we're talking about these where the votes are being tabulated, where the votes are being counted. Watchdogs have become frustrated when a data set's available in one county but not another. This bill aims to standardize at least some of the data available so that folks know they can get similar reports from every county. It means that when we're looking at data across counties, you can do an apples-to-apples comparison. Many of our counties are already doing the things in this bill, but the bill will require all counties to comply. Makes several changes. I'll highlight just a few. Require poll books to create a post-election list of who voted. We've seen problems where vote histories, who voted when and where, are kept in living databases. These databases change as voters move, and that makes vote history data degrade as time passes. This bill fixes that. We make provisional ballot reporting consistent, requiring them to be credited to early voting if cast then, and election day if the provisional ballots were cast then. We require post-election reconciliation by polling location to be done after the election and posted on the county's website. So for each polling location, a post-election reconciliation. We require daily reconciliation of ballots to voters during early voting. Some counties only reconcile once at the end of early voting. This bill requires it to be done every day. And if discrepancies are found, they must be investigated and fixed. We require reports of how many ballots were scanned by each scanner before the storage media is loaded onto the central accumulator. And finally, we require the central accumulator to produce reports showing ballots cast by location in addition to precinct. Both of those are important so that we can make sure the numbers are accurate and reconcile. And that's what the bill does, and now I'll yield for questions.
Members, any questions for Senate Bill 2217 with Senator Hall?
Thank you, Mr. Chairman. Yeah, you're talking about your daily reconciliation. You're talking about numbers of votes cast and people who showed up, not how they voted.
That's a great point, Senator Hall. It's not about how many votes each candidate received, but making sure that the number of people who checked in matches the number of votes that were cast, just the numbers. Thank you. That's important.
Other questions, members? None? Chair opens up public testimony for 2217. Pass the gavel back to Senator Hughes.
Thank you, Mr. Chairman. On Senate Bill 2217, the chair calls Ed Johnson, Dr. Laura Presley. Mr. Johnson and Dr. Presley, the only witnesses who have registered to testify on, for, or against Senate Bill 2217. And so if anyone else wishes to testify on, for, or against, please make your way to the table. Dr. Presley, welcome back. When you get situated, introduce yourself and give us your testimony.
Thank you, Chairman Hughes. I'm grateful for this bill. I like the bill. There are a few, what I would call technical, maybe inconsistencies, if I could raise those, if you would. If you go to page 4, line 4, it says the presiding judge of an early voting polling place. That actually should say early voting deputy clerk. It's just a technicality. In early voting, you don't have presiding judges. The early vote clerk is the presiding judge, and the deputy clerk is who's at the poll. That's just a very minor technical thing. If you look at line 14 and 15, we have, I think, a bit of a concern. Today, right now, if there's a discrepancy of more than 3 votes and voters, you go take everything down to central count to get it tabulated. What this is saying here is 1% of those numbers. So that's inconsistent with what we have in the code right now for those polling locations that actually do central count. Does that make sense? We're off there. That 1% is way high. It needs to be consistent, I think, and the Secretary of State can tell you the exact code number. I don't remember it right away, but I could help provide the language and reference so that that's consistent. Page 4, line 21. It talks about the central accumulator. Well, Texas Administrative Code, Part 4, Chapter D, Rule 8162, is a whole section on the central accumulator. And it would be really good if we could marry these up so that the code is not discrepant from this central accumulator definition. It's just a little bit off, and I think it'd be good to marry those up also. If we go to page 6, you're talking about a report that documents the number of results for candidates and propositions by polling location. I would like to see if we could add undervotes to that. Then you can really do a good accounting of everything. And what's concerning to me is that this would not go into effect until 2026. Right now, our voting systems are certified to do these reports. And I've given you the EAC certification. This is the 2015 certification that we are in Texas are certified to. And if you go to the second page there, it says the election, it's called the election management system for jurisdiction-wide accumulators can already summarize ballot counts and votes by tabulator, precinct, and polling place. So I'm not sure why we would wait until 2026 when our systems, as we sit here today, should be certified already to do it. And the Secretary of State made a comment yesterday in the House committee that one of the vendors is not able to do it. Somebody needs to explain that because they're supposed to be already certified by the EAC to do it. So there's just some technical, I think, adjustments I can help your staff with to make this matched up.
Well, thank you very much. Senators, any questions for Dr. Presley on 2217? No, thank you for this. We want to get the details right, so
You got
please, we've got some notes, but please share that with us as well if you don't mind. And so thank you for your.
But thank you for the bill. I love
yes,
the bill.
Thank you. We think it should help. It should make a difference. Thank you for your testimony. And
Bless y'all.
Please,
Thank
and please get that to us as
Yes,
well.
sir. Yes, sir. Thank
You
you.
always do. We appreciate that. And we'll call, is Christina, there's Miss Atkins. We'll call, as a resource witness chair, calls Christina Atkins. Ms. Atkins, welcome. We know you, but you know how to do this. Tell us who you are and who you represent.
Yes, sir. My name is Christina Adkins. I'm the Director of Elections for the Texas Secretary of State's office, available to answer any questions you might have regarding the bill.
Oh, thank you so much. And we were walking through some of the matters that Dr. Presley was pointing out to us. And so on page 4, line 14, where there's a reference to a discrepancy of 1% or more, and then there was the other provision that Dr. Presley referred to that talks about a smaller threshold depending on how many people voted in the election.
Yes, sir.
Would this conflict with that, or would they complement each other? Again, we want to make sure we get it right.
Absolutely. It's a great question, sir. So the other provision that was referenced was section 127.156 of the election code. That is an election day rule. This is creating an equivalent rule for early voting. And the reason why the numbers are different is because at election day, you have fewer votes cast at a given location, and so that discrepancy, a smaller discrepancy, should trigger a recount in those situations. For early voting, where you have 2 weeks of early voting in some cases, you may have 10,000, 20,000 ballots in Dallas County, for example, 20,000 votes cast at a given location for early voting. That discrepancy, I think a higher threshold is more appropriate for triggering a potential recount of those votes. It's consistent with the number of votes that were cast.
Okay. And then, thank you. And then on the matter of, at the end, on page 6, lines 9 and 10, about how the central accumulator, it must be capable of total number of votes received by each candidate and for or against each proposition for each polling place. Is that, and we were talking about how undervotes, the undervotes could also be shown. The current status of the requirements for certification of the machines, is this addressed?
So with respect to undervotes, I believe we actually already have some administrative rules that require the reporting of undervotes and overvotes, certain categories like that. So I think that would be included. It's consistent with what we already have required in some of our administrative rules. And if we need to issue provided this legislation prevails, if we need to issue some additional guidance or modify those rules to reflect the inclusion of this, we can do that. I think also with respect to some of the certification components, the language in those certification documents typically is referring to generating a report by location, so the vote totals for that given location. And this is going a step further and looking at a more comprehensive report that is a breakdown location by location. It's putting everything together in one report, a comprehensive breakdown.
So rather than a machine just having to produce it for that location, we'd have a comprehensive report broken down by location. Is that the idea?
Yes, sir. A comprehensive report of the total votes for that election, broken down by location.
Okay. Well, and again, we'll get the information from Dr. Preston. We'll all get together and get everything lined out. But Senator Hall, did you have questions? Go ahead. You're recognized.
One almost hypothetical question.
Yes, sir.
Right now, but with Election Day and early voting being two separate processes with different rules, if we were to move to a process where we had a single set of rules for the entire voting process, how would that affect this part?
How would it affect this, some of the
Yeah,
requirements in this bill?
Yeah, the requirements in that bill.
I think the biggest difference would be the timing of when we're generating some of those reports. If we had one combined voting period, we'd be generating reports again at the beginning of the voting period, again at the end of that voting period. But I think many of the requirements that are outlined in this legislation, it's about providing more accountability throughout the entire election process, providing for reconciliation on a day-to-day basis. So I don't think it matters if results are reported all in one group or in individual buckets. All of the requirements in this particular legislation would still be relevant and necessary.
Good. That's what I would make sure we had. Thank you.
Yes, sir.
Any other questions from Ms. Atkins on this bill? Thank you for being here. Is there anyone else wishing to testify on, for, or against Senate Bill 2217? Very well.
Chair lays out Senate Bill 2964. Asks the bill's author, Senator Hughes, to explain the bill. Senate Bill 2964.
Thank you, Mr. Chairman and members. Senate Bill 2964 is about ballots by mail. Back in 2023, the Senate passed Senate Bill 1599, which allowed for voters to correct errors in their early voting ballots through a corrective action form. So you vote by mail, and there's a problem. There's some kind of a defect. Maybe it's a clerical problem, but a real voter sent that in. So the idea is to allow a way for that voter to make corrections so that their vote does count. This gave voters the chance to address simple clerical errors such as a missing signature or maybe an incorrect voter ID number on their early ballot that would otherwise keep their vote from being counted. But Senate Bill 1599 left out early voting clerks as a group of folks who could notify a voter of a defect and send them a corrective action cure. So early voting clerks were not included in the list in Senate Bill 1599. This bill is a cleanup that will allow early voting clerks to notify voters of clerical errors and send those voters a corrective action form. This bill just makes sure that simple clerical errors don't stand in the way of all Texans having their votes counted and their voice heard, and that's what the bill does.
Any questions for the bill author, Senator Hall?
Thank you. You're talking about, this would be errors on the outer envelope that they're mailing in, not on their ballot.
Senator, that's a great point because the ballot, of course, doesn't have any identifying information. It's just got the votes. That's important.
Okay. Nothing, that's not, it's just the envelope. Okay.
That's exactly right. Thank you. That's important.
Any other questions? Senate Bill 2964 of the bill author? Seeing none. Chair opens up public testimony for Senate Bill 2964.
Thank you, Mr. Chairman. The chair calls Andrew Hendrickson, Ed Johnson, Laura Rogers, Honorable Laura Rogers. Again, looking for Andrew Hendrickson, Ed Johnson, and Honorable Laura Rogers. Is there anyone else wishing to testify on, for, or against Senate Bill 2964? Seeing none, public testimony is closed.
Senate Bill 2964 be left pending to a future date.
Thank you, Mr. Chairman. The chair lays out Senate Bill 2533 by Senator Middleton and recognizes Senator Perry to explain the bill on behalf of the author.
Thank you, members. Mr. Chairman, Senate Bill 2533, authored by Senator Middleton, delivered by Senator Perry, addresses the urgent need to safeguard legal education and professional eligibility in Texas by providing an alternative pathway for law school accreditation. The current system relies solely on the American Bar Association, ABA, for institutional recognition, which in turn determines whether law graduates are eligible to sit for the bar exam. However, recent federal scrutiny, particularly surrounding the ABA's diversity, equity, and inclusion standards, have raised questions about the ABA's future as a federally recognized accreditor. Even though the ABA enjoys a monopoly in the national recognition, this uncertainty places Texas law schools and their students at significant risk. Senate Bill 2533 proposes a straightforward but critical change. It requires all law school affiliated with public or private institutions of higher education in Texas to be accredited by an entity recognized by the U.S. Department of Education for institutional accreditation. By doing so, it opens the door for other credible accreditors to be considered, thereby reducing sole dependence on the ABA. It does not strip the ABA of its current role, but rather ensures Texas law schools have a fallback option should ABA lose its recognition or credibility. Mr. Chairman, there is a committee sub.
Senator Hall sends up the committee substitute, and Senator Perry is recognized to explain the substitute.
The committee substitute simply amends the designated federal body to United States Department of Education, or correctly, as its successor of interest to ensure the greatest flexibility of our law institutions. So if there's no longer a Department of Ed, he's got it covered. With that, I don't think I have any answers for questions, but I would try.
Thank you, Senator Perry. Any questions for Senator Perry on behalf of the author? All right, great layout. We'll open public testimony on Senate Bill 2533. Public testimony is now open. Is there anyone wishing to testify on, for, or against Senate Bill 2533? Anyone wishing to testify on, for, or against 2533? Seeing none, public testimony is closed. Bill is left pending at this time. We'll now consider some pending business that's already been heard and move those forward. The chair lays out as a matter of pending business Senate Bill 1721 by Senator Middleton about transfer of the licensing and regulation of charitable bingo to the Texas Department of Licensing and Regulation. There is a new committee substitute. Senator Middleton sends up the committee substitute, and the chair recognizes Senator Middleton to explain the substitute.
Thank you, Mr. Chairman. Members, as in the original bill, the committee substitute to Senate Bill 1721 transfers the regulatory authority of charitable bingo from the Texas Lottery Commission to TDLR. We've been working closely with members of TDLR on this substitute. The changes that were made were done with their direction. We've confirmed that TDLR, that the new substitute will aid them in smoothing this transition of charitable bingo to TDLR from the Texas Lottery.
And thank you, Senator. Members, any questions for Senator Middleton on the substitute? Senator Perry.
I was told there's a sunset in 4 years or a review.
Yes, so,
It's in there?
sorry, 1 second, let me pull it
I
up.
mean, if it's in there, don't worry about it.
Yeah, yes.
Any other questions for the author on the committee substitute? Very well. Senator Middleton moves that we adopt the substitute. Is there objection? The substitute is adopted. Senator Middleton moves that Senate Bill 1721 as substituted be reported favorably to the full Senate with the recommendation that it do pass and be printed. 1721. Will the clerk call the roll?
Bettencourt, Birdwell, Hall, Hinojosa, Middleton,
Aye.
Parker, Perry, Schwertner, Saffarini, Paxton, Hughes.
Yes, there being 6 ayes and no nays, Senate Bill 1721 as substituted will be reported favorably to the full Senate. Senator Paxton moves that Senate Bill 1721 be recommended and certified for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business Senate Bill 517, Senator Middleton's bill on gambling devices, including 8-liners, and Senator Middleton sends up a committee substitute, and Senator Middleton is recognized to explain the substitute.
Thank you, members. Laying out the committee substitute on Senate Bill 517. And it's obviously was apparent in the committee hearing that we need additional work based on Fort Worth's testimony. We've worked with Senator Perry and his office as well as representatives from Fort Worth on the sub. And what basically it does is the definition of 8-liners was removed. The committee substitute removes this specific definition, entirely opting instead to expand and clarify the general definition of gambling device. In section 47091, the defenses to prosecution are removed. This was necessary to avoid the fuzzy animal defense. Section 4701B was removed. The committee substitute increases the criminal penalties from a Class A misdemeanor to a third-degree felony. The committee substitute goes further by explicitly naming gift cards as prohibited items alongside cash equivalent. And the repeal of local government code subchapter E was removed, which was necessary to ensure that local law enforcement can continue to identify who is operating these parlors so they can go after them, hold them accountable.
Thank you, Senator Middleton. Senator Paxton, you're recognized.
Thank you, Mr. Chairman. And thanks, Senator Middleton. I appreciate the bill and all of the input that you've sought and received. And a conversation we've talked about before, but just for clarity and intent, how would this bill impact games and devices that are 100% skilled?
Right, sorry, forget that. Predominantly skilled, that's still in the law right now. So, if 100% skilled, it's obviously predominantly skilled.
Okay,
So
thank you.
The individual's not going to be prosecuted. That's the goal here. We're going after the operators.
Thank you. Thank you, Senator Middleton. Thanks, Mr. Chairman.
Any other questions for the author on the substitute? Very well. Senator Middleton moves that we adopt the committee substitute. Is there objection? The substitute is adopted. Senator Middleton moves that Senate Bill 517 as substituted be reported favorably to the full Senate with the recommendation that it do pass and be printed. 517. Will the clerk call the roll?
Bettencourt, Birdwell, Hall, Hinojosa, Middleton,
Aye.
Parker, Perry, Schwertner, Saffarini, Paxton, Hughes.
Aye. There being 6 ayes and no nays, Senate Bill 517 will be reported favorably to the full Senate. Senator Paxton moves Senate Bill 517 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out Senate Bill 240, Senator Middleton's bill about policies for entering or using certain private spaces, Senate Bill 240, and Senator Middleton sends up a committee substitute, and Senator Middleton's recognized to explain the substitute.
Thank you, Mr. Chairman. Members, obviously the original as-filed version of Senate Bill 240 seeks to protect the privacy of women and facilities that are owned or operated or controlled by political subdivisions and state agencies. And after stakeholder input and careful deliberation, the committee substitute preserves all of these protections. However, we needed amendments to specifically address the issues with family violence shelters. So the committee substitute clarifies that only family violence shelters that serve women are included in the bill. Mixed facilities are removed. Further, the substitute makes it clear that male children under the age of 18 may accompany their mothers or stepmothers in a female-only family violence shelter, as we heard from a witness in this committee, why that's important, and it requires that inmates be housed according to their biological sex with implementation by TDCJ and in compliance with state and federal law. Finally, the substitute requires political subdivisions and state agencies not only to adopt policies regulating female-designated private spaces, but also to enforce them.
Thank you, Senator Middleton. Members, any questions for the author on the substitute on Senate Bill 240? Senator Middleton moves that we adopt the committee substitute. Is there objection? Hearing none, is so ordered. And the substitute is adopted. Senator Middleton moves that Senate Bill 240 as substituted be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll? 240.
Bettencourt, Birdwell, Hall, Hinojosa, Middleton,
Aye.
Parker, Perry, Schwertner, Saffarini, Paxton, Hughes.
Aye. There being 6 ayes and no nays, Senate Bill 240 as substituted will be reported favorably to the full Senate. As a matter of pending business, the chair lays out Senate Bill 2051, Senator Birdwell's bill regarding the impeachment process. He has previously laid out a committee substitute. Senator Perry moves that we adopt the substitute. Is there objection? Hearing none, the substitute is adopted. Senator Hall moves that Senate Bill 2051 as substituted be reported favorably to the full Senate with the recommendation that it do pass and be printed. Senate Bill 2051, will the clerk call the roll?
Bettencourt, Birdwell, Hall, Hinojosa, Middleton,
Aye.
Parker, Perry, Schwertner, Saffarini, Paxton, Hughes.
Aye. There being 6 ayes and no nays, Senate Bill 2051 as substituted will be reported favorably to the full Senate. Okay. There was no testimony against or votes against, so okay. All right. So will Senator Hinojosa moves that Senate Bill 2051 as substituted be recommended for placement on the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. Yeah, that's true. The author can pull it off if he wants to discuss it on the floor. Yeah, that's right. Great point. So the chair now lays out as a matter of pending business in Joint Resolution 68. This is the joint resolution that accompanies the legislation regarding impeachment that Senator Birdwell presented to us, SJR 68. Senator Hall moves that Senate Joint Resolution 68 be reported favorably to the full Senate with the recommendation that it do pass and be printed, SJR 68. Will the clerk call the roll?
Bettencourt, Birdwell, Hall, Hinojosa, Middleton,
Aye.
Parker, Perry, Schwertner, Saffarini, Paxton, Hughes.
Aye. There being 6 ayes and no nays, Senate Joint Resolution 68 will be reported favorably to the full Senate. As a matter of pending business, the chair lays out Senate Bill 801 by Senator Menendez relating to the issuance of birth certificates to a homeless individual, Senate Bill 801. Senator Hall moves that Senate Bill 801 be reported favorably to the full Senate with the recommendation that it do pass and be printed. 801, will the clerk call the roll?
Bettencourt, Birdwell, Hall, Hinojosa, Middleton,
Aye.
Parker, Perry, Schwertner, Saffarini, Paxton, Hughes.
Aye. So that vote is going to
You needed to vote no. Yeah.
So show the chair voting no. And the tally being 3-3, that the bill, the motion fails to pass. And so on the prevailing side, I can move to reconsider the vote, whereby the bill failed to pass, and it will be allowed to be considered again at a future committee hearing. So
Later.
the chair moves to reconsider the vote, whereby Senate Bill 801 failed to be reported favorably to the full Senate. Is there objection to the motion to reconsider the vote? Okay, hearing none, the motion prevails. Senate Bill 801 will be left pending this time. As a matter of pending business, the chair lays out Senate Bill 1200. Senate Bill 1200, and that's Senator Colcourt's bill about disclosure of financial relationships and civil actions against U.S. defense contractors. Senator Colcourt, there's a committee substitute that was previously sent up, and she explained it to us. Senator Hall sends up the committee substitute. Is there objection to adoption of the substitute? Hearing none, the substitute is adopted. Senator Hall moves that Senate Bill 1200 as substituted be reported favorably to the full Senate with the recommendation that it do pass and be printed. 1200. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton,
Aye.
Parker, Perry, Schwertner, Saffarini, Paxton, Hughes.
Aye. There being 6 ayes and no nays, Senate Bill 1200 as substituted will be reported favorably to the full Senate. Senator Paxton moves that Senate Bill 1200 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business Senate Bill 1410, Senator Campbell's bill on the Gulf of America, Senate Bill 1410. Senator Hall moves that Senate Bill 1410 be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton,
Aye.
Parker, Perry, Schwertner, Saffarini, Paxton, Hughes.
Aye. There being 6 ayes and no nays, Senate Bill 1410 will be reported favorably to the full Senate.
Yeah. Yeah. Yeah.
I'll move for local.
Campbell.
Senator Paxton, Senator Hinojosa moves that Senate Bill 1410 be recommended for placement on the local and uncontested calendar. Is there objection? Hearing none, it's so ordered. Right. Yeah, I think it is. Okay, good. The chair lays out as a matter of pending business Senate Bill 2626. Senator Campbell's building about medical education and certainly pregnancy-related conditions. Senate Bill 2626. Senator Perry moves that Senate Bill 2626 be reported favorably to the full Senate with the recommendation that it do pass and be printed. 2626. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton,
Aye.
Parker, Perry, Schwertner, Saffarini, Paxton, Hughes.
Aye. There being 6 ayes and no nays, the Senate Bill 2626 will be reported favorably to the full Senate. As a matter of pending business, the chair lays out Senate Bill 2681, Senator Betancourt's bill on third-party challenge to a voter's registration. Senate Bill 2681. Senator Hall moves that Senate Bill 2681 be reported favorably to the full Senate with the recommendation that it do pass and be printed. 2681, will the clerk call the roll?
Bettencourt, Birdwell, Hall, Hinojosa, Middleton,
Aye.
Parker, Perry, Schwertner, Zaffarini, Paxton, Hughes.
Aye. And Senator Birdwell, thank you, sir. So there being 7 ayes and no nays, Senate Bill 2681 will be reported favorably to the full Senate. The chair lays out as a matter of pending business Senate Bill 1717 by Senator Middleton. Senator Middleton sends up a committee substitute, and he is recognized to explain the substitute.
Thank you, Mr. Chairman, members. This is just the Ledge Council version, aiming at the Gulf of America.
Very good. Any questions for the author on the substitute? Senator Middleton moves that we adopt the committee substitute, Senate Bill 1717. Is there objection? Hearing none, it is so ordered. Senator Middleton moves that Senate Bill 1717 as substituted be reported favorably to the full Senate with the recommendation that it do pass and be printed. 1717. Will the clerk call the roll?
Bettencourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton, Hughes.
Aye. There being 6 ayes and no nays, Senate Bill 1717 will be reported favorably to the full Senate. And Senator Paxton moves Senate Bill 1717 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business Senate Joint Resolution 63, SJR 63 by Senator Middleton, constitutional amendment regarding the Gulf of America. And Senator Middleton sends up a committee substitute, and the chair recognizes Senator Middleton to explain the substitute.
Thank you, Mr. Chairman, members. This is just the Ledge Council version for SJR 63.
Any questions for the author on SJR 63 as substituted? Very well. Senator Middleton moves that we adopt the committee substitute. Is there objection? Hearing none, the substitute is adopted. Senator Middleton moves that SJR 63 as substituted be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Bettencourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton, Hughes.
Aye. There being 6 ayes and no nays, Senate Joint Resolution 63 will be reported favorably to the full Senate. And that's a JR, so you probably want that on the floor anyway, probably. All right.
Okay. All right. All right. Chair lays out as a matter of pending business, Senate Bill 1626. There is a committee sub, and the chair recognizes Chairman Hughes to explain the committee sub.
Thank you, Madam Chair. The committee substitute simply clarifies the original intent of the bill, covering large platforms that should be treated as common carriers. The committee would ensure that smaller platforms are not implicated. This is the same language we included in the original House Bill 20 on this same topic, and this what Senate Bill 1626 is in the same code, and so that's what the substitute does. I'm happy to answer questions.
Members, any questions on the committee sub? Hearing none, Senator Hughes moves that we adopt the committee substitute. Is there objection? Hearing none, the substitute is adopted. Senator Hall moves that we report the committee substitute to Senate Bill 1626 favorably to the whole Senate. The clerk will call the roll.
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton,
Aye.
Hughes.
Aye.
There being 6 ayes and 0 nays, committee substitute to Senate Bill 1626 will be reported favorably to the whole Senate. Okay. Yeah. Yes. All right. Members, the chair brings up Senate Bill 1845. Senate Bill 1845 relating to the registration as a lobbyist of persons who engage in certain lobbying activities on behalf of foreign adversary. 1845, sorry. Senator Hughes moves that we report the bill favorably to the whole Senate. The clerk will call the roll.
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton,
Aye.
Hughes.
Aye.
There being 6 ayes and 0 nays, Senate Bill 1845 will be reported favorably to the whole Senate. Senator Middleton moves that Senate Bill 1845 be recommended and certified for placement on the local and uncontested calendar. Is there objection? Hearing none, it's so ordered. All right, Chair lays out Senate Bill 1862 as a matter of pending business. And we have a committee sub that's already been laid out. Senator Hughes moves that we adopt the substitute. Is there objection? Hearing none, the substitute is adopted. Senator Hinojosa moves that we report the committee substitute to Senate Bill 1862 favorably to the whole Senate. The clerk will call the roll.
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton,
Aye.
Hughes.
Aye.
There being 6 ayes and 0 nays, the committee substitute to 1862 will be, the committee substitute to Senate Bill 1862 will be reported favorably to the whole Senate. Can we do? Okay. Senator Perry moves that the committee substitute to Senate Bill 1862 be recommended and certified for placement on the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. I didn't see that one. It's so tiny. Chair lays out as a matter of pending business Senate Bill 1863 relating to the conduct of randomized county election audits. Senator Hughes moves that we report the bill favorably to the whole Senate. The clerk will call the roll.
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton,
Aye.
Hughes.
Aye.
There being 6 ayes and 0 nays, Senate Bill 1863 will be reported favorably to the whole Senate. Okay. Yes. Fiscal note. Mhm. Thank you. Chair lays out as a matter of pending business Senate Bill 2216 by Senator Hughes relating to the security of election system equipment. Senate Bill 2216. Senator Hughes moves that we report the bill favorably to the whole Senate. The clerk will call the roll.
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton,
Aye.
Hughes.
Aye.
There being 6 ayes and 0 nays, Senate Bill 2216 will be reported favorably to the whole Senate. Okay. Senator Middleton moves that Senate Bill 2216 be recommended and certified for placement on the local and uncontested calendar. Is there objection? Hearing none, it is so ordered.
Thank you, Madam Chair. And I thank each member and their excellent staffs and our wonderful committee staff and all the folks that work hard to help us do this. And folks have to clean up after we leave. We'll help them a little bit. But thank you, everyone, for being here. And if there's no other business to come before the Committee on State Affairs stands in recess up to the call of the chair. Good evening.